Good morning, good afternoon, and good evening, and welcome to the webinar, The Suspension of the Indus Waters Treaty, Impacts on Transboundary Water Governance in South Asia and Beyond, hosted by the Asia-Pacific Interest Group of the American Society of International Law. My name is David Devlamic, and I am Associate Professor at the School of Law of Chongqing University in mainland China, and I'm also co-chair of the Asia-Pacific Interest Group. Tonight, we'll talk about the Indus Waters Treaty in the Indus River Basin, shared by India, Pakistan, China, and Afghanistan, with a majority of the river basin in India and Pakistan. To govern these shared waters, India and Pakistan signed the Indus Waters Treaty in 1960 after tripartite negotiations between India, Pakistan, and the World Bank. The treaty divided the Indus River system between India and Pakistan, assigning the three eastern rivers to India for its exclusive use, and the three western rivers to Pakistan, providing exclusive rights to each of the states, except for domestic, non-consumptive, and restricted agricultural use by the other party. It includes an obligation to prevent significant harm, but this is limited to pollution and waste. Information is to be shared between the parties, collected daily and transmitted monthly. To facilitate cooperation, it established the Permanent Indus Commission, comprised of a commissioner from each state. Any questions regarding the interpretation or application of the treaty are to be first examined by the commission, but if a dispute arises, it can be settled by neutral expert or a court of arbitration. Disputes have thus far largely revolved around the establishment of upstream hydropower, including the Baglahar hydroelectric plant, settled by neutral expert in 2007, the Indus Waters Kishinganga arbitration, settled by a court of arbitration in 2013. The most recent dispute has led to the convening of two separate forums, with Pakistan requesting arbitration and India requesting settlement by neutral expert. The treaty has survived throughout periods of war and significant tension between India and Pakistan. But after recent attacks in Indian-administered Jammu and Kashmir, India placed the treaty into abeyance. Pakistan has responded strongly, referring to any change in allocation as an act of war, and India's Home Minister has recently stated the treaty may never be restored. Regarding the ongoing dispute settlement procedures, the Permanent Court of Arbitration on June 27th indicated that it can proceed with the Indus Western Rivers arbitration and released its award on issues of general interpretation of the Indus Waters Treaty in early August. India, however, did not participate in the proceedings, which are ongoing. To discuss this complex landscape and to have a very forward-looking, neutral discussion on the situation, we have two speakers. We have Melissa McCracken, assistant professor at the Fletcher School of Tufts University in the United States, where she holds the William Mumma Professorship in International Environment and Resource Policy. We also welcome Professor Alistair Rowe-Clark of the School of Law, Northumbria University in the United Kingdom. Before we begin, please note that the views expressed here are the personal views of the speakers and do not represent those of their institutions or affiliations. Also, please note that this session is being recorded and will appear on the American Society of International Law's YouTube channel in the near future. Finally, please use the Q&A function to submit your questions and comments. These questions will be addressed by the speakers in the latter half of the webinar. To get our conversation started, I would first like to pass it off to Dr. Melissa McCracken and ask, what is the current status and situation of the Indus? How did we get to this point? And how is the current situation impacting cooperation between India and Pakistan and the implications for the broader region? Melissa?
Thank you, Dave. Thank you, everyone, for being here. It's my pleasure to talk with you. I'll just share my slides. So we just have some visual aids as we discuss the current status. So as Dave presented in his overview, the current status is that the treaty is being held in abeyance by India. And how did we actually get here? So we can start with a pretty narrow look temporally, where we start with the terrorist attack that took place in Jhelum in India-administered Pakistan on April 22nd. This attack was claimed responsibility by the Resistance Front, and it was essentially a terrorist attack that caused the deaths of 25 to 26 Indian citizens. After this attack, we see a press release and a press briefing being held by the Indian Ministry of External Affairs, which stated that the treaty will be held in abeyance until Pakistan credibly and irrevocably abjures its support for cross-border terrorism. India did formally notify Pakistan of this decision to hold the treaty in abeyance on the following day, April 24th, in a letter from India's Secretary of Water Resources, stating that the security uncertainties impeded India's full utilization of the rights under the treaty, and the breaches committed by Pakistan, essentially refusing to respond to India's request to enter into negotiations, is thus in breach of the treaty, and therefore the government of India decided to hold the treaty in abeyance with immediate effect. What we end up seeing is then an escalation of rhetoric between the two states following this announcement, where we have India saying that not a drop of water will be released into Pakistan, and subsequently on the same day, we see that the National Security Committee of Pakistan released a statement opposing the announcement to hold the treaty in abeyance and saying that it's a lifeline for the Pakistani people and it should be safeguarded at any cost, and that any attempt to stop or divert the flow belonging to Pakistan would be considered an act of war and responded in full force across the complete spectrum of their national power. Following this, we see some actual actions being taken once the treaty was held in abeyance, and we start to see towards the end of April and into May that there are unexpected rises in the water levels of both the Jhelum rivers as well as the Chenab rivers in both in Pakistan administered Kashmir, which did cause some flooding within the region and Pakistan called for India to actually continue with the notification process that would have been under the treaty. And so we end up seeing continued types of rhetoric along these lines, where in June, India stated that the water treaty would never likely be restored, and Pakistan similarly responding that they're calling for India to rescind this stance and to restore the full implementation of the treaty. And most recently, we actually see last month, on September 19th, the Union Minister for Housing and Urban Affairs for India stated that the water saved due to the suspension of the treaty will be made available to Delhi, Rajasthan, and other cities within 1 to 1.5 years. So we are continuing to see an escalation of both action and rhetoric moving forward. But this isn't happening in absence of other actions. And so, as was mentioned in the introduction, there are ongoing dispute resolution processes that are occurring. And these happen to be two parallel dispute resolution processes. So what we see is that India, once it asks for or sets the treaty in abeyance, Pakistan requests the Permanent Court of Arbitration that is currently running the arbitration process under this dispute resolution mechanism of the treaty, asks for review by the court to see if this process will still continue. India similarly requests that the neutral expert proceedings, also a mechanism under the dispute resolution provision for the treaty, be held, since it is no longer considered valid by India as the treaty is being held in abeyance. On June 27th, the arbitration court awarded a supplementary award saying that it is competent to rule on the process, on the dispute, regardless of India holding the treaty in abeyance, saying that the abeyance does not limit the competence of the court, and that it is found that this unilateral decision by India was initiated after the proceedings began, and therefore it continues to be competent to resolve the dispute. The neutral expert has also released several letters that were published just recently, including the latest in September, finding essentially very similar concepts to the Permanent Court of Arbitration, saying that the neutral expert process is also competent to continue with these separate proceedings, even though India has withdrawn from the neutral expert process. And so we actually see then the award by the Permanent Court of Arbitration on August 8th for the general interpretation of the treaty, saying that the issue of the dispute resolution or the issue of the dispute that is under consideration by the court is that India should let the waters flow for the western rivers under the design and operation as stated by the requirements in the treaty. So we've looked really close at what's happening right now, but how did we actually get here? What led to this process and this abeyance of the treaty happening? So I want to step back to the very beginning of the creation of India and Pakistan as they're currently established with the partition in 1947. And so this historical context is particularly important to consider because the borders were drawn, particularly the line of control, were drawn more on religious grounds and did not pay much attention to the hydrology of the Indus Basin. And so what we end up seeing is that India controls the upstream barrages that are part of a very extensive and cohesive agricultural and canal system that was developed by the British during colonial rule. And so we end up seeing that the way that the agricultural infrastructure was designed at that point in time was not taken into consideration when the two states became independent during partition. We see then the signing of the Indus Waters Treaty after a decade of negotiation in 1960s, and we see that this treaty has historically been considered very effective. Just 5 years after the signing in 1965, during the Second Kashmiri War, the states continued to maintain and implement the delivery of water, or exchange of information, as all the elements of the treaty that were required, even during this high period of conflict and military standoff. But shortly after, we start to see disputes beginning to arise over the interpretation of various provisions within the treaty. In 1968, the Salal Dam dispute begins. It is resolved through bilateral negotiations, which ultimately were held within the capacity of the Permanent Indus Commission, which is established under the treaty, and led to the signing of the 1978 agreement on the Salal. In 1984, then, we see the Tubal Navigation Project, also known as the Wolar Barrage, also becoming a point of contention. This was escalated to the Permanent Indus Commission, which was unable to resolve after many years of bilateral talks. And so actually, India abandoned the project and is considering now resuming the project as of this recent abeyance. In 1988, we see the beginnings of the Kishinganga hydroelectric project dispute arising, as well as the 1990, just a couple years later, the Baglahar hydroelectric project. Both of these, again, begin dispute resolution proceedings within the Permanent Indus Commission, continue with diplomatic channels. The Baglahar project becomes escalated to use the neutral expert provision of the dispute resolution mechanism, while the Kishinganga is brought to the Court of Arbitration. Both of those disputes have awards presented, the neutral expert in 2007 for the Baglahar project, and in 2013, the Permanent Court of Arbitration issues award on the Kishinganga. But what we actually end up seeing is even though this award on the Kishinganga was released in 2013, there were questions regarding some of the implementation of provisions, and the dispute actually continued. And so both India and Pakistan continued to negotiate over the Kishinganga, and then the Rattle hydroelectric project was brought into the discussions over 2014 and 2015. And we end up then seeing in 2016, India requesting the Kishinganga and the Rattle projects to go to a neutral expert process, while Pakistan requests those two to be preceded by another court of arbitration. The World Bank puts a halt on both of these proceedings as the body to essentially appoint members of the Court of Arbitration or the neutral expert. And it wasn't until 2022 that we see the World Bank recognize that these parallel proceedings are going to be continuing, and so they begin the appointment of both of these proceedings at the same time. During this time, India has continued to call for renegotiations of the Indus Waters Treaty. First in 2021, we see another in 2022, and most recently in 2023. And as a result of the continued disputes, we also see India put a halt to the meetings of the Permanent Indus Commission starting in 2022. So the last meeting of the commission was then in 2022, and they have not continued up to now. So we see a long process of various disputes and increasing escalation and a kind of a lack of resolution of many of these issues as we move through time. And so this essentially gives us a summary of how we actually got to the treaty being held in abeyance. We start with the impacts of the imperialist designation of the line of control and the legacy of partition on how it divided the agricultural system that was already established within the basin. We see a broad basin context evolving with climate change impacts, heavily increased water and energy demand in both countries, as well as increasing population and shifts in geopolitics of both states. But ultimately, we have an underlying persistent conflict that has maintained throughout this time regarding the interpretation of the treaty itself on how India is allowed to develop upstream hydropower projects on the upstream western rivers. And so ultimately, this has led to increasing politicization and securitized perspectives over the Indus waters and has brought it into the broader geopolitics, where we see the Indus Water Treaty abeyance happening following a terrorist attack in Kashmir. Ultimately, then, what we see in terms of impacts for cooperation between the two states, historically, this has been a very effective treaty and very successful. It's 6 decades of cooperation, many disputes that have been resolved that it can really be attributed to the design of the dispute resolution mechanism, even during points of high conflict and even war between the states. But what we end up seeing is the shifts in these contexts, the intertwined nature of the Indus Waters Treaty with the broader geopolitics of the region means that the water has become equated a lot with national security. And so we see more the securitization and politicization of the water conflict. So now we end up having missile strikes that have been happening in Kashmir following the terrorist attack. We've had a cut of diplomatic ties between the two states, reduced and halted trade, and that both states have withdrawn from other agreements beyond the Indus Waters Treaty. We've seen the threats that India has said that they'll stop all the flow. Some studies have started to look at the feasibility for this, and what we actually see is, at least in the near term, there's very limited capacity for India to stop all of the flow to Pakistan. At this current point in time, it's estimated that they would only really be able to stop flow for about a month before they would have to continue to release flow downstream in order to prevent damage to infrastructure or flooding within Indian territories. But this would require long-term infrastructure construction to build more storage capacity upstream in India if they did want to follow through on their threat. However, I think this is an important part to note, that it takes a long time for infrastructure to be developed, so that can provide time and opportunity to hopefully resolve the issue diplomatically. From a regional perspective, we see across South Asia that climate and environmental security risks are increasing. We see increases in migration, economic, and security impacts. Broadly, the region has a practice of more bilateral agreements over their transboundary waters rather than focusing on a basin-wide or multilateral approach. And so as a result of all of these, we're seeing reduced trust happening that could happen in our existing arrangements with other states, as well as future arrangements. In particular, thinking about the agreements between India and China on the Brahmaputra, some of which will be renegotiated or coming up for expiration soon, and the potential implications that China might see if India has not been a trustworthy partner in the Indus. Now, India is the downstream state in the Brahmaputra, and what impact that could have on their future cooperative relationships over the other transboundary river. So with that, I'll hand it back to you, Dave.
Thank you very much, Melissa, for that overview of the history of the Indus Waters Treaty and the current conflict. I'd now like to pass it over to Alistair and ask, well, why do we need treaties? What are the benefits of having a treaty? And has a water treaty ever been suspended for? And how might we look or assess that suspension?
Yeah, thanks, Dave, and thanks to you and Melissa for setting the context and the background. So, yeah, taking that first question first, what are the benefits of having a treaty? So you could look at it under the principle of Pacta sunt servanda, which is it's reflected in the Vienna Convention on the Law of Treaties. It's reflective of customary international law. And there we see in Article 26, it states every treaty in force is binding upon the parties to it and must be performed by them in good faith. So pretty simple provision, but very important. It's actually an obligation that was quoted by India in a letter to Pakistan on the 24th of April, where it was stated that the obligation to honor a treaty in good faith is a fundamental to a treaty. Similar language was used by the International Law Commission when they were drafting the Vienna Convention on the law of treaties, saying it was this norm is fundamental principle of the law of treaties. Why is it fundamental? Essentially because without such a commitment, then treaties are pretty much not worth the paper they're written on. It's basically the same idea as a contract. Just say you want to buy a piece of land. You want something in writing, right? That says that proves that you have right of ownership and all of that entails. So you could build a house on that land. Your rights will be protected and so on. So Pacta sunt servanda gives this the principle gives the assurance that the actions in line with the rights and obligations within a treaty will be respected by others. So this is really critical in relation to transboundary waters. If you're making significant investments which rely on the water within a basin, then you want to be sure that those investments are protected and respected. So we could say that Pacta sunt servanda is at the heart of the benefits of international law and entering into a treaty. But if we look at it more broadly, thinking about the more broader benefits of entering into in these transboundary water agreements, and Dave, if you go to the next slide, we could see despite the occasional hiccups, by and large, treaties have worked well for countries sharing transboundary waters. We tend to focus on when things go wrong, but it's important to note that most transboundary water treaties are working well. We just don't hear about them. I analyzed about 400 transboundary water agreements for a recent book I published on implementing transboundary water agreements. And while there are significant gaps in terms of coverage of rivers, lakes, and aquifers, it's pretty impressive to see the practice. And there's a lot that we can learn from the practice. And what do we learn? Well, some of the benefits are captured nicely in the practical guide. Their practical guide, which says these agreements help promote social, economic, environmental benefits, benefits that far exceed what's possible through unilateral action. Look at the example of the Senegal River, where joint infrastructures provided benefits to countries in terms of reliable, optimal supplies, water, energy, and so on. Look at the Danube, where the countries work together around climate change adaptation, early warning of extreme events, joint monitoring and assessment. Look at Brazil and Paraguay and the Itaipu Binational Commission, where even in times of drought, the countries have managed to come together to share water and energy based on a principle of equity. So there's many more of these examples, and none of them would be possible without being underpinned by legal agreements. We can also look at the last round of reporting under 652, which measures transboundary water cooperation and coverage of operational agreements. And their countries themselves have reported some of the benefits of having these agreements in place. Receiving financial support for joint activities, dispute avoidance, enhanced regional cooperation, developing agreements, strengthening political will, long-lasting and sustained cooperation, stakeholder engagement, improved water management, joint plans and programs, better knowledge and understanding. So it's also important to recognize that the process of developing an agreement can in itself also be beneficial. It can help build confidence and trust, allow for the exchange of information, provide for joint activities, set priorities, foster shared understanding. So there are many benefits, I would say, to countries entering into agreements. So then, Dave, for that second part, has a water treaty ever been suspended before, or how might we assess the suspension of a treaty? I'll take both those questions together. So to preserve the strength of this overarching principle of pacta sunt servanda, it makes sense that any possibility of suspending a treaty is extremely limited and narrowly interpreted. Some treaties include a provision related to suspension, but the Indus Treaty doesn't. India's letter to Pakistan on the 24th of April stated that the resulting security uncertainties have directly impeded India's full utilization of its rights under the treaty, and Pakistan has refused to respond to India's request to enter into negotiations as envisaged under the treaty, and is thus in breach of the treaty. So then India go on to say, the government of India has hereby decided that the Indus Water Treaty 1960 will be held in abeyance with immediate effect. However, the letter doesn't give any explicit legal grounds upon why they're on how, to justify their holding the treaty in suspension. So yeah, if they use the term abeyance, but if we take abeyance to mean suspension, we can see that there are several grounds upon which unilateral suspension of a treaty might be permitted. So these again are set out in the Vienna Convention on Law of Treaties and reflective of customary international law. The customary international law nature of these provisions was endorsed by the International Court of Justice in the Gabčíkova-Načmos case, where Hungary sought to suspend and subsequently abandon a 1977 bilateral treaty it had entered into with Czechoslovakia. So here is an example of a country seeking to suspend a treaty. But ultimately, Hungary was unsuccessful in persuading the court. If we look at the grounds, there's basically three grounds within the Vienna Conventional Law of Treaties. So you look at Article 60, states that a material breach of a bilateral treaty by one of its parties entitles the other to invoke the breach as a ground for terminating a treaty or suspending its operation in whole or in part. A material breach can be defined as the violation of a provision essential to the accomplishment of the object and purpose of a treaty. So it's not clear from the 24th of April letter what provision of the Indus Treaty has been violated by Pakistan. To rely on this justification, it would certainly have to be shown that the breach was to the core commitments within the Indus Treaty. And if it was a claim of material breach, you could also question whether the countries wouldn't first resort to dispute settlement provisions under the treaty to settle any disagreements. Then second grounds would be supervening impossibility of performance. So within this ground, you really would require a permanent disappearance or destruction of an object indispensable for the execution of a treaty. So examples are submergence of an island, drying up of a river, destruction of a dam due to an earthquake. But it doesn't appear to be the case, or certainly India is not using that as justification. So the last one is around fundamental change of circumstances. So India's letter does mention fundamental change of circumstances, although it's more in relation to the call to modify the treaty rather than an explicit and direct grounds for why they're suspending the treaty. Article 62 was used as an argument for unilateral suspension. If it was, India would have to demonstrate that there had been a fundamental change of circumstances, and it hadn't been foreseen by the parties. So this is something that Hungary argued in the Gabčíkova-Načmos case. They argued political changes, shift away from the Soviet Union, move towards market economy, progress in environmental knowledge, development of new norms, prescriptions under environmental law, all constituted fundamental changes of circumstances from when the bilateral treaty was adopted and entered into force in the 1970s. However, the court, drawing from the Vienna Convention, concluded that the fundamental change of circumstances must have been unforeseen, and the existence of circumstances at the time of the treaty's conclusion must have constituted an essential basis of the consent of the parties to be bound by the treaty. Then, taking environmental knowledge, new norms of environmental law as examples, the court was clear in the Gabčíkova case that these can't be said to have been completely unforeseen, and also noted that there was flexibility within the treaty to accommodate such developments. So if we think about the Indus context, there's no denying that there's been profound changes have resulted from population increase, deepening knowledge of environmental aspects of the basin, impacts of climate change, glacier melt, and so on. But the most appropriate course of action would be to use the treaty itself to address these issues, I would say, or look to modify the terms of that agreement consensually. So to sum up, I would say there's many benefits of countries entering into transboundary water agreements, and these benefits are evidenced by a lot of state practice. And the suspension of a treaty, there are grounds by which unilateral suspension is allowed, but they are, I would say, in very limited circumstances. Thanks. Over to you, Dave.
Thank you very much, Alistair. We'll move to our last question, which is for both of you, and more of a forward-looking question. What pathways are available for India and Pakistan to resolve this dispute? And what about the treaty? Can we renegotiate? Should we amend it? If so, how might we actually amend the treaty? What types of treaty provisions might we look for in an amended Indus Waters Treaty? Maybe I can first pass it off to Melissa.
Sure. So I think it's a complicated situation in terms of the broader question on what are the pathways that are available, because it really depends on the broader political situation. And so if we end up wanting to create pathways, we need to work towards depoliticizing the Indus Waters Treaty within the context of the broader geopolitics between the two states. So helping to reduce the rhetoric in the media around the, stopping the flow, or that it will be an act of war, that can be a first step in helping to open those pathways potentially. Beginning to resume meetings of the Permanent Indus Commission, or if it's not possible at this point in time until the abeyance issue has been dealt with, to have some kind of additional meeting where they're still doing the data and information exchange, particularly the notification for any flood releases downstream, to ensure that there's not damage to loss of to property as well as loss of life. Those can be done even without the particular mechanism of the Permanent Indus Commission, but we can still maintain the essence and the idea of cooperation while the broader conflict is being addressed through more formal mechanisms. So the other piece could be looking at that the fact that the basin is not just two states. India and Pakistan, yes, are the two dominant territories, but there's also land in the Indus Basin within Afghanistan and within China. And so potentially opening the conversation to more actors could create more of a basin-wide approach. I think at this point in time, from a political stance, that's unlikely to happen until there's more trust between the two states as well as within the broader basin riparians. But that is an opportunity in the long term, I think, for building more pathways to help address the underlying issues for increasing demands for water and energy and population growth within the region that should be considered in the long term. And I'll let
Thank you very much,
Ali talk about the treaty.
Alistair?
Yeah, thanks. Yeah, so I mean, basically, if we talk about changes to the treaty, ultimately we need the consent of both parties. There is an obligation to negotiate the terms of an agreement or any modification in good faith. So if we look at the Lac-Lanu arbitration, 1957, it was stated that the reality of the obligations thus undertaken is incontestable and sanctions can be applied in the event, for example, of unjustified breaking off of the discussions, abnormal delay, disregard of the agreed procedures, systematic refusals to take into consideration adverse proposals or interests, and more generally in cases of violations of the rules of good faith. So we have an obligation to enter into negotiations around entering into agreements or modifying agreements. Within the Indus Treaty itself, there's actually an article, Article 12.3, which, and Dave, I think I had a slide which gave you the text of that article. The provisions of this treaty may from time to time be modified by a duly ratified treaty concluded for that purpose by the two governments. So basically, the parties can modify the treaty if they so agree, and should do that based on its principle of good faith. And then there's various options. It would be you could amend one or several provisions of a treaty. So you see, for example, the UN Water Convention was amended. Article 25 was amended to allow all UN member states to join the convention. Before it was only open to member states of the Economic Commission for Europe. Another option would be to develop some sort of supplementary text, which is very common in the case of a framework agreement that might set out general principles for sharing transboundary waters, might establish an institutional arrangement, but then a lot of more of a detail comes later in these supplementary texts. So you could look at the 2002 framework agreement on the Sava River Basin for an example. They've developed protocols to the agreement, one on navigation, on water pollution, flood protection, sediment management. And these instruments don't affect the founding text, if you like, the framework agreement. You could revise the text itself, sort of a more radical overhaul of the agreement. So you see, in 1994 Okavango Agreement, for example, was recently revised to take into account subsequent agreements, the 2000 revised SADC Protocol, the 97 Watercourses Convention. A similar process is going on for the 2000 Orange Senku Agreement. So there is there's a possibility to also look at the revision of agreements. Yeah. So I think they're sort of broad brushed options you have for amending the agreement.
Thank you very much. I think we will now open it up to the questions from the audience, and we do have a few questions in the chat box. If you do have any questions, please put them in the Q&A function, and I'll be addressing them to the speakers. Rahul Singh is asking, well, where does international law stand when two conflicting parties make claims for water sharing? So perhaps maybe, Alistair, you could just touch a little bit on some of the substantive rules and the other methods of water sharing and water allocation under treaties around the world?
Yeah, sure, Dave. So, as I said, there's a great practice of countries cooperating over transboundary waters, and a lot of that has been codified in the 97 Watercourses Convention, which I mentioned. So a global convention which sets out the basic rules and principles by which states can share their transboundary waters. At the heart of that convention are the principles of equitable and reasonable use, and the duty to take all appropriate measures to prevent significant transboundary harm. And so they're basically the core principles. And ultimately, it boils down to fairness, weighing up all the rights, interests, competing interests and uses to come up with an equitable result. And what that means in practice really varies across all the basins. Every basin is different. What I would emphasize within the package of international water law principles within the Watercourses Convention, I mentioned also the Water Convention, within a lot of the treaty practice, there's a lot of emphasis on process. So in order to tailor equity to a particular basin context, then you need rules around sharing data information, notifying of plans for developing infrastructure projects, for example, on a basin, and so on. So process also becomes really important, I would say, in determining what is equity. So there's this kind of two parts of a puzzle. The substantive norms essentially boiling down to equity, and then certain procedural aspects that can help countries and provide that platform by which they can reconcile their competing interests.
Thank you very much. I think I'll pass the next question to Melissa. It's more of a comment than a question. It's very worrying that this could create a dangerous precedent among different countries who tend to be water hegemons. Such countries could easily suspend their transboundary water agreements where it's convenient for them. And the anonymous asker asks, it raises this question of the resilience of transboundary water agreements and the valid reasons for their suspension. So I just thought maybe, Melissa, if you might want to comment on this comment. Given your background and your work on what makes an effective water treaty and what effective transboundary water cooperation looks like.
No, I very much agree with our commenter that it can be potentially worrying. And I think in light of the broader shifts we're seeing with multilateralism more globally, it can be quite worrying. And so we've seen more instances of not quite as far as taking a treaty to be held in abeyance, but states withdrawing from participation in various organizations. We saw, for example, that Guinea stepped out of the OMBG for the Basin Organization for the Gambia, and then they came back a couple of months later. Tajikistan has stepped out of IFAS. And so we have various examples where different countries have started to kind of use their participation in cooperative frameworks as a tool to push forward more unilateral agendas in some respects. And so I think this really comes back to some of the key principles that Ali was mentioning, that if we need to continue to maintain these underlying principles, equitable and reasonable use, no significant harm, these customary law elements. And so if we can maintain those, continue to negotiate in good faith, to build the trust, to build the relationships, to build these cooperative processes, we're going to have more effective cooperation and hopefully build the resilience. It can't just be the legal and the institutional components of more structural pieces, but we need also the walls that connect the structural pieces of our house of cooperation, if you follow my analogy. And so we need these relational components. We need to see positive outcomes. We need to see these mutual benefits. And if we can get that, we can create what we would call more of a virtuous cycle of positive reinforcement for cooperation and more trust in multilateralism, and then we can move forward with that resilience.
I really like your analogy of the house of cooperation with international water law and transboundary water treaties as one perhaps major component of that house's foundation. I want to ask my own question to Alistair. And Melissa identified that a lot of the disputes are looking at hydropower and whether or not India has the right to develop hydropower and in what way. And I'm wondering how we might overcome this obstacle of hydropower installations, which seem to keep appearing again and again in various disputes between India and Pakistan, especially given some of your more recent work, which focuses on hydropower governance on transboundary waters.
Yeah, thanks, Dave. I would say that, I mean, generally, transboundary hydropower is no different to other uses, activities on transboundary waters. So ultimately, it's about sharing and cooperation. And using the platform of international water law, using these treaties as a basis for doing that. And I think we can also see, I gave the example of the Senegal River, and we can see, and Itaipu as well, actually, but we have lots of good examples of where countries have come together through these joint infrastructure projects, through joint planning, to maximize the benefits of a particular basin, uses of a particular basin. And far exceed what they might be able to achieve unilaterally. So I think we already have, we already have a blueprint. We already have the experience. We have a lot that we can learn from within these treaties. And I think more specifically, then we also have useful laws, policies, standards that can help states reconcile their competing differences around the projects. And again, a lot of it, I think, comes back to process and ultimately communicating on future plans, sharing data information, assessing potential impacts of projects, making sure you're also assessing cumulative impacts. So yeah, I mean, if you look at the World Bank standards, International Hydropower Association, the global water conventions, et cetera, et cetera. I think there you're not struggling to find appropriate laws and standards for that. And I think in there's opportunities that might help in the case of India and Pakistan specifically, but also just generally to help guide countries in their planning of these projects. And ultimately, the best thing to have in place is a treaty framework, a platform by which this discussion can take place through some sort of joint institutional body, and that's clearly far superior than what can be achieved through when there's an absence of such an arrangement. Yeah.
We have another question. Is there custom or emerging custom in international environmental law, such as transboundary harm, that could provide a remedy for unilateral exit in the case of the Indus or in other similar circumstances? Ali, would you have any thoughts on that?
Yeah, I think I picked up on it a little bit. If we think about this grounds for unilateral suspension, and arguing there's a fundamental change in circumstances. And there certainly the opinion of the International Court of Justice in the Gabčíkova-Načmar case, thinking about the 1977 treaty between Hungary and Czechoslovakia, they were very reticent to say that that's really that would be a good justification. And so I think it would be similar. And I mean, and we should also recognize that treaties are not static instruments, right? That they are interpreted in light of changing factors and circumstances. Even the Indus Treaty could be used as an example, and you can see that in the Kishinganga arbitration that Melissa mentioned, there was a discussion around environmental flow, so basically incorporating environmental flow thinking into the interpretation and implementation of a treaty, which both countries readily agreed to. They had some differences of opinion on what that flow might be, but they accepted that this was a contemporary concept and could be incorporated into the interpretation of a treaty, essentially. So I think that's really where you see that these types of arguments around customary environmental law, transboundary harm, you would rather see them being incorporated into the interpretation of the treaties, yeah, rather than as a claim for an unforeseen fundamental change in circumstances.
Alistair, I'm going to pick on you once more as we have another question directed at you. What is your perspective in the context of international law? How is the obligation to give notice and the relationship between such notice and the following consent or not?
I'm not sure what it's notice of. I mean, I mean, there's a couple of things. I mean, one is about notice of a suspension, but then there's notice of planned measures. And as I was talking about notice of planned measures, I'll maybe guess it's that. In terms of notification, it's set out quite clearly in the 97 Watercourses Convention, this obligation to give timely notification of planned activities. And I think here's a good example of where there's a lot of procedure and detail on the procedure to help implement the substantive principles. So there's clear obligations to give timely notification of planned measures, to give the notified states time to consider that notification. 6 months, it could be extended to 12 months if depending on the nature scale of the project, and then for various steps in terms of what happens if the countries disagree in terms of a project after that, which is all set out in the 97 Convention if someone wants to have a look at the detail.
I think we have time for one more question, and as I'm the moderator, it'll be a question for me. Recently, in the past few months, Bangladesh has acceded to the 1992 Water Convention, making it one of the only parties in South Asia. How will this affect Bangladesh's cooperation with India, and how might we look at South Asia and its relationship with the global water conventions, both the Watercourses Convention and the Water Convention, in light of this dispute between India and Pakistan? Alistair?
Yeah, okay, that's an interesting one. I mean, I think it's great. As I mentioned, the Water Convention is now open to all UN member states to join. And I think there's been a lot of interest since it's been opened up. for countries outside the UNEC Economic Commission for Europe region to join the convention, particularly I think across Africa, a lot of new parties from Africa. But I think that's a really important step for Bangladesh to become a party. I would say this is the Water Convention as a global framework, and through its institutional framework platform, it has a meeting of the parties, secretariat, different working groups. There's a working group on IWRM, which is taking place today. It provides great opportunities for countries to come together, to exchange experiences when they do have challenges in implementing their treaties, to look at what's happening elsewhere in the world, and exchange ideas. There's a twinning program set up for new parties and older parties to share experiences. So I think there's great opportunities there. I think that's great that Bangladesh has acceded to the convention. I think there's great opportunities for other countries to use the convention as a global platform for strengthening the negotiation, adoption, implementation of their transboundary water agreements.
If we have time for one more very brief question. What legal mechanisms can be put in place to ensure that PPPs, I assuming public-private partnerships, are incentivized to invest in sustainable water-saving technology while also ensuring compliance, both national and international environmental regulations? So perhaps maybe touching on some of the the standards around hydropower and hydropower development. Alistair, I think I'll pick on you again for this one. My apologies.
No, yeah, not such a straightforward one to answer, but I would say if you recall when you asked me about the benefits of agreements, and one of the main benefits that countries themselves had actually identified through the 652 reporting was around financing and leveraging finance for projects. So in short, I would say in terms of illegal mechanisms, what's really crucial within a transboundary basin setting is that there are legal agreements in place, a legal and institutional framework in place by which these investments, all types of investments, including PPP, is implemented, and that goes back to that assurance, pacta sunt servanda. There needs to be that assurance that all of these investments will be protected, and I still think that treaties, basin treaties, bilateral treaties offer the best assurances of that by which these investments can be developed in a cooperative way, in terms of maximize benefits, ensure that they're equitably consistent with principles of equitable and reasonable use, no significant harm, and so on. So the short answer is through treaties. Yeah.
Thank you very much. With that, I would like to conclude this webinar. Thank you very much for this very rich discussion. We kind of see that there's a need to depoliticize the situation, to assist in building trust, and that treaties eventually can kind of work to help settle disputes. We can settle them through those treaties as part of our house of cooperation, to use the words of Dr. McCracken. So I would like to sincerely thank both Alistair and Melissa for your discussion tonight. And very much like to thank the audience as well. Thank you all for coming. Please note that this will be posted on the American Society of International Law's YouTube channel in the near future. If you are interested in this topic and other topics of international law that relate to the Asia-Pacific region, we'd strongly encourage you to become a member of the American Society of International Law, as well as the Asia-Pacific Interest Group. You can also find us on LinkedIn. The Asia-Pacific Interest Group has a LinkedIn page that you are all free to join. And keep an eye for an upcoming webinar that we'll be arranging on the Climate Change Advisory Opinion and Perceptions and Perspectives from the Asia Pacific region. So with that, thanks once again.